pleasure to follow the honourable gentleman, the member for Glasgow North East, and also to pay tribute to my right honourable friend, the member for Fareham, in what is, I regard, a very good bill, which displays the diligence and expertise to which he brings to his ministerial duties. But a point I'm sure he would be quick to recognise, and a point on which I have some sympathy with the line pursued by the member for Morley and Outward, is that no regulatory structure is a panacea against regulatory risk. And it's also an issue, I mean, we saw that with the cases highlighted in terms of BCCI, for example, with the Bank of England. And it's also an issue in terms of this bill that it doesn't address really the core lesson from the recent regulatory failure in terms of the failure of capital and liquidity rules, where in essence what we're debating today is the supervisory arm of what is an EU regulatory policy agenda. Fortunately, the member for Stone is not in his place. Otherwise, I'm sure he will be intervening at such a point. For all the strengths of this bill, I want to touch, if I may, on three areas where I fear expectations might be raised amongst our constituents, and yet the regulator may not have the power to go with those. Firstly, the extent to which the Financial Conduct Authority will have an interventionist approach and its objective of promoting competition. Its ability to achieve speedy resolution, an issue addressed briefly by the member for the cities of London and Westminster. And also whether it will achieve effective enforcement against individuals, the issue of whether there should be strict liability. And indeed, as the member for West Suffolk touched on, whether indeed there should be criminal sanctions, a point floated by Lord Turner in the RBS report, but not answered there. And if time allows, I also want, if I may, to put forward a proposal on which there may be some cross-party consensus in terms of the way fines imposed when there is a regulatory breach are addressed and what is done with those funds. I'd be grateful if my honourable friend could address what the risk tolerance of the new consumer regulator will be. I think there's often a misconception when in the past people have talked about regulators in terms of zero failure. And it would be welcome to get some sort of sense as to at what point the new regulator would be judged if it has failed to intervene where there is a failure, or to what extent a failure within the regime is tolerable depending on its size and scale. And likewise around the competition objective. It's interesting, and it has been touched on by members, in terms of the lack of a power to refer directly to the Competition Commission. It has to be referred via the OFT. And there is a potential there for two regulators to take different interpretations and for some duplication of both of costs, but also some confusion as to where the power of one regulator starts and ends and the role of another. And thirdly, in terms of speedy resolution, the point touched on by my honourable friend, the member for the cities of London and Westminster, in terms, if one takes the example of payment protection insurance, if you have a regime where a firm can appeal to the regulator and seek a 90-day review, and then it can judicially review that decision, which could stretch things out for around a further 18 months, you can have an instance where there is a mis-selling case that occurs, and yet a firm, for tactical reasons, can stretch things out in order to be able to use the funds in the short term. And my colleagues' thoughts on that would be welcome. But I think the key issue, and the issue that always arises in my constituency, is this sense of grievance that there haven't been enforcement actions against individuals. And that really was at the heart of why the Treasury Select Committee required a report from Lord Turner. But I don't feel there's anything really in this bill that addresses that issue. It doesn't say whether we're going to have strict liability. There's no proposals to frame criminal sanctions, and I think for what it's worth, that would be very difficult to frame. But the real issue within banks is that senior executives protect themselves through complex management structures, by devolving control functions lower down the organisation, so there's a buffer between them and the decision-making, so they can say that they're knowingly blind. Risk functions often report into finance, where there's a potential conflict of interest, and even compliance officers often get to shape meetings with supervisors, notwithstanding the more intensive regime that is currently being followed by the regulator. And so a key issue I think we need to address either in this bill or in future legislation is how individuals at the top of banks are held accountable when there are mistakes. And on that, it may be that my right honourable friend needs to also have discussions with the Lord Chancellor because to an extent both judicial review but also the role of the tribunal and the different risk appetite at the moment of the tribunal are issues that do need to be addressed, and those are issues which ultimately, given their judicial nature, fall within the Lord Chancellor's department, but go to the heart of whether people get a sense of justice being done where there are serious failures. Moving away from some of the areas of misconception, I want to put forward an area on which I would welcome a response from both front benches, and on which I think there could be scope for some positive reform. And that is what happens when a firm pays a regulatory fine. It may surprise members of the House that currently under Section 16 of Schedule 1 of FSMA, where there is a fine for a regulatory breach, that money doesn't go to good causes, doesn't even go to the Treasury. My right honourable friend might think the Treasury is a good cause in itself, but it doesn't even go to the Treasury. That actually goes to reducing the levy paid by other financial firms. So when a bank breaks the rules, at the moment, that money goes to reduce the levy paid by other banks. And over the last 2 years, that amounts to £166 million. Now, I know a number of members are very keen. The biggest all-party group in the House revolves around financial education. It may be that such a fund can be hypothecated and used in a more constructive way, and I would welcome it as part of the wind-up, the comments on that, notwithstanding the recognition that firms are contributing more to financial education as it is. But it is odd that they actually benefit from the regulatory breach of other firms. In concluding, Mr Deputy Speaker, because I'm aware of the time-limited nature of contributions now and to allow time for others to contribute, this is a very good bill, but as I said at the opening, there will be failure. And I think when there is failure, it is the most reasonable of expectations to be able to expect to have an independent report. And it's instructed that Lord Turner's report came from someone who is not a neutral player. I'd welcome clarification from the Minister as to how much Lord Turner's report has cost to compile. But I would like to see in the bill some scope for an independent report in the future if we are in the fortunate position of having a further regulatory failure. The fact that the Treasury Select Committee had to seek its own private experts in order to comment on Lord Turner's report in a way speaks volumes for concerns there, and I think that's a small matter that could be tightened up in terms of the committee work on the bill. Overall, I think it's an excellent set of measures, and I will have great pleasure supporting my right honourable friend in the lobby this evening.